віщання з користувача UBA Students League 2, і я просто можу не розуміти, чи так має бути, чи щось не так.
Все добре.
Ну, добре.
Ми питали дозволу на трансляцію на YouTube. Якщо ви її зараз заперечуєте, то ми її...
Ні, це не, я не про трансляцію кажу. Зараз просто я чую, що в конференції хтось говорить, а я не розумію, це так потрібно, чи має бути тиша?
Ні, все добре. Трансляцію на YouTube розпочати, тому можемо починати наш раунд.
Ні, мається на увазі, що ще хтось говорить на фоні.
Так.
У нас такого не чути, це у вас.
В мене продовжує йти. Це моя проблема, перепрошую, все, готовий починати.
Okay, good afternoon. My name is Valeria Oksenyuk, and my co-agent is Daria Loposhuk. I'm a student of Lviv National University of Ivan Franko. I'm a third-year student of international relations, especially international law. You?
Okay, my name is Daria Loposhuk. I am a third-year student from National Law University, and I'm studying law. Yes.
Okay.
That's all.
Our respondent.
Good evening, I suppose, the Honorable Chair, Honorable Judges of the Court. My name is Adil Abduramanov, and I, together with my co-agent Dmitro Kirichenko, have the honor to appear before this court. Today, together, we will address to the Honorable Court the points of defense.
Thank you.
Thank you. That will be all of our presentation.
Let's start. Okay. Good afternoon, Mr. President, Madam President, distinguished member of the court. My name is Valeria Oksenyuk, and name of my co-agent is Daria Loposhuk, and we agent for applicant Aizen Uzheniev. We kindly ask this court to reserve 10 minutes for my part of Aizen Uzheniev arguments. It is my pleasure to present before this honored court the following submission on behalf of Aizen Uzheniev. I thank the court for allowing me the opportunity to present my arguments. Respondent has registered several things, such as the first is trademark Martin State verbal mark, second, international trademark application with extension of Ukraine to Ukraine and Poland. The third, trademark Martin verbal mark and international trademark with extension to Ukraine and Poland. Industrial design on the exterior to the robot, that is a character of a computer game, Martin State. International registration of the hack system with extension to Ukraine and Poland. Trademark device mark, international registration with extension to Ukraine and Poland. Those registration violates applicant's author rights by copyright the name of applicant's book and the illustration inside that book that was written on the 20th of January 1995. Due to Part 4, Article 6 on the protection of trademark rights for goods and services, the trademark cannot be registered as the name of work of literature known as in Ukraine and character from them, works of art and fragment thereof, without the contest of the copyright owners. The first specific issue I would like to refer to on behalf of applicant is that according to the provision of Ukrainian legislation stated above, the title of work, the heroes of the work, and the works of art are objects of copyright of Ukraine and therefore cannot be used and registered as trademark in Ukraine without the permission of the author of these works.
Well, also according to the Berne Convention of the Protection of Literary and Artistic Works, according to Article 5 of this convention, the provisions of which are set out above, a trademark which is the subject of copyright acquired in any country party to the Berne Convention for the protection of literary and artistic works may not be registered in any country for any goods or services. In this case, the principle of territoriality doesn't work. Yes. Also, in the case of Lutz City, District Court of Volyn Region, the court satisfies the applicant's claim for illegal use of the original title and character of the literary work without the author's permission. The fact of violation of property rights was determined peace agreement between the parties. As a result of the infringement of the applicant's rights, losses were inquired in the form of lost profits. That is, the proceeds weren't received as a result of the registration of the trademarks. In dispute, the claimant haven't sent across the border the books written by him personally, and as a result, the contract terms for exporting of the books to India weren't fulfilled. The applicant didn't receive revenue in amount of $100,000. It has been I would like to enter my submissions and ask the court to stop infringement, illegal use of trademarks and prohibit the continued use of such trademarks: trademark Martin's Estate, verbal mark, international trademark application with extension to Ukraine and Poland, trademark Martin, verbal mark with extension to in Benelux, international trademark application with extension to Ukraine and Poland, trademark device mark with extension in Benelux, international registration with extension to Ukraine and Poland. Stop infringement, illegal use of industrial design and prohibit the continued use of such industrial design. Industrial design on the exterior of the robot that is the character of a computer game Martin's Estate, and international registration of the Hague system with extension to Ukraine and Poland. To charge damages in amount of 2,700,000 of orders the respondent to pay the costs and expenses. Thank you. May it please the court.
I guess now the part of the questions, right? I will give the word to my colleague for first two questions.
Yes, thank you. The question is as follows. Which evidence of the trademark confusions which occurred in real life you can present?
We have evidence that we registered under national procedure in Benelux, and that the trademark Martin Estate is already registered. Like that evidence.
Perhaps I haven't been clear in my question. When I refer to confusion of trademarks, I refer to the action in which the end consumer might be confused when seeing the trademark Martin's Estate. So does this so do you have evidence of such confusion happening? Do you have perhaps an expertise that shows that these trademarks are similar?
Yes, the first thing is that due to the Ukrainian legislation, we have not the obligation to register the name of the book. The guard comes from its creation because of Ukrainian legislation. Yes, and due to the Article 9 law of Ukraine copyright and related rights, a part of a work that can be used independently. Yes, due to the Article 11 law of Ukraine copyright and related rights, the copyright of work arises from the fact of its creation. The origins and exercise of copyright doesn't require the registration of the work or any other special design of the work, as well as the completion of any other formalities.
Well, thank you for your answers. And now it's, if there are no objections, my turn to ask questions. And my question will be following. Was the book of the Ivan Ozhenev available in languages other than Ukrainian? And if answer is no, in what way developers of the game could have got acquainted with such kind of story? Thank you.
The answer is that I have no information about if the book was in any other language than in Ukraine, but still we have got a Berne Convention for the protection of literary and artistic works, the provisions of which are set out about a trademark which is the subject of copywriting acquired in any country party to the Berne Convention. And Benelux is a part of the Berne Convention, Poland is a part of a Berne Convention, and Ukraine is a part of a Berne Convention. And yes, that works may not be registered in any country for services. In the case, the principle of territoriality doesn't work. It's like
excuse me, miss, excuse me, I beg your pardon, but can you answer the question how your client could have known about the plot and about the book?
He could have been in Ukraine. He could have used. He could have had like a friend or any other person that translated to him the plot of the book.
Are these your allegations, or you have evidences of what you are saying?
It is our view of it. And we have evidence that about Berne Convention and about participants of it, and that.
These are international treaties, and
Yes.
these are not evidences, these are international documents. But I'm asking about the evidences that are proving your answers. I'm sorry, you are muted.
Yeah. Okay, so we have written that book in Ukrainian, and also after the translation in English, and we want that book to translate in English. So.
Did you understand the answer, the question? I mean, the question. How could Kyle, your client, possibly know the plot and the existence of the book?
Anyway, it was available in Ukraine for any person who wanted to buy it. And if it was available, he could have known about that book, he could have known about the plot, he could have known even Ukrainian language to read it.
So you allege that he had that possibility, and that's it.
Of course, it was available even in the internet, and during surfing the internet, you can find and buy this book.
Okay.
So let me rephrase what you just said in order to understand, perhaps. So do you claim that there is no, no, the question is as follows. Do you have evidence that backs your allegations regarding the book being available to the Dutch developers, which, well, do not have Ukrainian language as an official language, and nor they use it as, I suppose, as a means of communication between themselves. So, can you back this up by something?
It's harder to understand the question. Can you repeat, please?
So what you've just said in your answer back to the honorable judges is that the book was available to everyone to read. However, we know that prior to it being translated to English, it was only available in Ukrainian language. So do you have any evidence that that a Dutch team of engineers and an American team, I suppose, of game developers would understand Ukrainian language to the level to understand literary work and to adapt its plot to use in their respective works?
Okay, we have the book. The book is already created. And while we have book, and everybody of the world can understand that book, namely Martin Estate, it is also evidence that the book is already
the book is published, written, and it is available for anyone who wants to read it. It is available only in Ukrainian language, but still you can find a person who can read it in Ukrainian language, and then he could translate it to you in English language, and
we have not a translator, and even so, it's not a problem to understand.
Thank you.
Okay, thank you.
Yes, we understand. And if there is no other questions,
if you please. The question is just a remark to the representatives of the defendant. Could you clarify why are you asking about the knowledge of the book by the developers? Is this material for defense of the current defendant, or are you representing anyone who has been a developer in this game?
Well, thank you for this question. As we believe, our question was relevant to the case because precisely we know that that the trademark Martin's Estate was registered by our defendant, which in turn registered it after he purchased the property rights of the game Martin's Estate from Real Game Real Play LLC, which are the developers of the game Martin's Estate. So we suppose that the party of the claimant alleges that the developers used the book in order prior to their registration of the trademark Martin's Estate in the first place. And then, well, this trademark was transferred, its title was transferred to Mr. Kyle, the defendant, in 2014, I suppose. So so our question was relevant because we didn't, not because we represent the game developers, but because because the original owner of the trademark were the defendants, were the game developers. I'm sorry.
Thank you.
Okay, and I suppose we have a bit of minutes, and I would like to address one more question. The claimant party argued that the image trademark was schematically represented in the book, and thus this schematic representation served as the basis for the image trademark, which was registered by our client. Thus, the question will be following. Could you please explain your understanding of the notion schematic representation and in what manner and how it should correlate with the final image trademark? I mean, namely, which parts are presented in the image trademark and how is it reasoned in legal sphere? Thank you.
Okay, can you repeat the question?
Because we have got a fluent connection.
Yeah, sure. I have asked, could you please explain your understanding of the notion schematic representation? Because it is crucial for understanding how the schematic representation has been grounded for the image trademark.
Okay, thank you for question. And
Yes, due to the Article 8 Law of Ukraine Copywriting and Related Rights, subjects of copywriting are works in field of science, literature, and art. And our schematic imagination in the book of our client was the work of art, and it is also guarded by the legislation of Ukraine and by the Berne Convention. And due to the fact of this copywriting, you have the respondent have
violate our rights.
Could I kindly clarify the defendant's question? As I understand, the defendants are asking, is there any similar image or identical image in the book which is identical to the registered visual trademark owned by the defendants? Are they the same or not?
Due to the case and what was written in the case, they are similar, and it can, by doing
the book, it was the schematic picture of the robot even. So,
and by making the expertise, it can be
also clarified that it is.
Are they confusingly similar or just similar, having like the same number of legs, hands, and head? What's the difference between the two pictures? Are they confusingly similar or just they have the same like general features?
Thank you for question. It is similar.
Due to our case, it is similar, the same.
The same picture, the same.
Yeah, but we are in the legal courtroom, and just to say it is similar, it's not enough, I guess, in our opinion. Can you name the requirements according to which we can state about the similarity or identical, or whether they similar or identical? Because these notions are a bit different in our sphere. Thank you.
There was made an expertise, and due to the fact of its making, it was concluded that they are similar.
You say you have concluded forensic, right? And
yes.
But has the forensic been submitted by the court?
It was made.
I must interrupt you because there is no more time for the questions, and if the defendants want to say their part, please proceed to your part of your motions.
Thank you, Your Honor, and honorable judges of the court. We would like to reserve 10 minutes for our argument, equally divided among myself and my co-agent, namely 5 minutes for each. Well, my part will cover the issues regarding the industrial design, as it was mentioned by the claimant, and my co-counselor will focus on the issues regarding the trademark. So if it pleases the court, we will proceed to our points.
Yes. Honorable judges, if it pleases the court, I will proceed. Well, concerning trademarks, we reject the pleading of claimant to recognize the trademarks Martin and Martin's estate. Let me consult my papers with the numbers. Martin is the number 5011 and Martin's estate is the 5601, which owned by the defendant. We reject that these two trademarks infringes the rights of the Ivan Ogenev, namely the claimant, and here's why. The above mentioned trademarks owned by Kyle have been registered by the Benelux Convention procedure, namely originally in the Netherlands. And prior to the date of the registration, the book of the Ivan Ogenev was accessible in the world only in one language, which is Ukrainian. And as we have clarified previously, it was hardly possible that the developer teams, which was the originally creators of the game, the rights of which then Kyle has bought, hardly could have known the Ukrainian language and being acquainted with this book. And furthermore, prior to the Clement's translation of the short story, there was no literary work under the name Martin's Estate, but there was under the name Mayetok Martina, which is completely different and cannot be equalized. And then we reject the claim to render trademarks under the defendant's ownership hereby invalid and to render the image trademark of Robert Appearance, namely number 5011, invalid due to the infringement of the copyright of the claimant's story. Simply because, as we have obviously clarified before, it was schematic image, and schematic image in our belief cannot be related to the complete image trademark which we have, which the Kyle have registered, because they are relative trace which wasn't presented in the schematic image, obviously. Well, now I will give the word to my colleague concerning the industrial design.
Thank you. So regarding the issues of industrial design, we reject the claim of the claimant to render the industrial design of the robot Martin's Appearance under number 1231, registered under the Hague Agreement with extension to Ukraine, as invalid because of it, firstly, lacking novelty, and secondly, infringing the copyright of others. Well, in the context of an industrial design, a novelty requirement is met if the complex of an invention's essential characteristics has not been made public prior to the submission of an industrial design. The illustrations contained in claimant's short story, while describing the robot's appearance, are vague and exist solely to give a general impression of a character to the reader. Usually, the short stories of science fiction genre do not involve the blueprints explaining the functional peculiarities of every single mechanism, because A, it would be too boring for the reader to read, and B, because the technologies being used in science fiction genre usually are too sophisticated or too resource consuming to be used realistically outside outside the story. So therefore, it is safe to say that the illustrations do not have the unique complex of essential characteristics of the robot, because the illustrations are schematic by nature, and so the allegations of the industrial design lacking novelty and therefore invalid has no legal basis. With that, we would like to we plead to the court to reject the above-mentioned claims by the claimant in the parts they were addressed to the defendant, which is our client, Mr. Kyle. Thank you.
Thank you.
Do applicants have any questions, the defendants? Please unmute yourself if you're speaking.
Can I have a minute?
No.
Sorry, you're muted again.
Can we have a minute to discuss it between?
You have 30 seconds.
Can I ask a simple question in a while?
To us, you mean?
Yes.
Yes, sure.
How come there is coincidence in the name of the robot? Both robots have the same name, Martin. Could you explain the understanding how, whether such a name could be known for anyone, for any other robots, or probably there is some specific intended naming of the robot number 2, which you are owning?
Thank you for this question, Your Honor, and I would like to give the word to my colleague Dmytro Kirichenko to answer this.
Yes, thank you, Adil. Thank you, Your Honor. Well, we have to admit that the word Martin and Martin is highly common in the European nations and peoples because it is of Roman origin. Thus, it is highly common to see the such kind of names around the Europe, as I have stated. But another part of my answer will be following. The name of Robert is actually the name of the family he got in, and I think it is quite logical that the family has given the name to the robot. But concerning another part of your question about the another robots with such name, I don't know whether it is right to say it here, but in our world, in our universe, we have the author Asimov.
Isaac Asimov.
Yeah, which book obviously has been a prototype for such case, I guess.
Yes, and what my colleague is referring to is that, well, it is not unusual in the plot of any kind to involve a family that somehow obtains the robot and therefore coexists with it. So in the science fiction genre, there are only like two ways that a human being can obtain a robot under his like servitude. So it could construct the robot, or a human could buy the robot. So here in the Mayatok Martina, the short story by Yazin Ozhnev, we see that the family has bought the robot, and well, referring to the doctrine of savoir-faire, in which certain elements of the genre are vital to that genre and therefore cannot be copyrighted, as that would in turn damage the literary industry as a whole, because it would monopolize certain elements that are vital to the plot. So we believe that such a coincidence is merely an homage to the genre itself, and has no prior connection and involves no prior connection of the short story and the game.
Well, can we ask a question?
Sure.
Yes. Well, how can you how can you explain that the robot copies the name of the main character of the book, and it also copies what was it doing in the plot of the book, and what is it doing in real life? Like, it is the similar due to the plot. In the plot, the robot was making wood features as your robot does, and we believe so that it violates our rights.
Thank you for this question. I believe we have already mentioned the answer to this, but but it won't be an issue for us to repeat again. So the reason why the robots are named the same, because the name itself, Martin, is quite usual in the European tradition. So it wouldn't be unusual for anything to be named Martin, precisely a humanoid robot. Now, regarding the actions of the robot in the plot and the actions of the robot in real life, as you have mentioned, I believe you're referring to his woodworking techniques. Am I correct?
Yes, I think.
No, there's a device.
Correct.
No. Am I correct that you are referring to the woodworking that both robots seemingly undertake in? Well, I'm going to go with the assumption that you are, and go further. So, regarding the woodworking, there isn't much that you can assign a robot to do. Usually, robots in the science fiction plots are assigned manual labor for them to construct certain simple figurines, for example. And so this existing in the plot of the short story is complete does not mean that this is original to this short story only. Now, regarding the game, it so happened that the original author of the idea of Real Robot Martin was Richard Goldway, which coincidentally was the player of the game Martin's Estate. And what we know about Mr. Richard Goldway here is that his family is known for woodworking, and so it wouldn't be unusual for a person growing up in the family of woodworkers to pick an option of woodworking to his robot in the game, which allows such an option. So being offered being offered an option of woodworking from the range of possibilities in the game is to the discretion of the Mr. Richard Goldway, which is not represented here. And so this robot in the game was then the prototype for the real robot, which simply copied the functions and the design of the robot from the game, and has no prior connection to the short story's plot. And to finalize, I would like to refer to the merger doctrine, which is used to describe that ideas cannot be copyrighted, only expressions of the said ideas. And so what we believe you're referring to is an idea of a robot doing woodworking, which cannot be protected by copyright, only its expression. So with that, we thank you for this question. And if you have any other questions, feel free to ask them.
Okay, we have a question. Can we ask? Okay. If you know, you have international registration of hack system with extension to Ukraine, Poland. Okay, but how it can be extension in Ukraine while we have already book written in Ukraine? So the question is, we ask court to stop their international registration with extension to Ukraine. How can you argument this?
Well, thank you for your question, but nevertheless, it seems like the question mainly to the national register organ, but not for our party. But nevertheless, I will answer that. We have the book called Martin's Estate, and the copyright is protecting such book regardless of the actions taken towards the registration. But we didn't have and still don't have the trademarks with a similar naming. And thus, when the International Bureau extended the registration to the Ukraine in Poland, there was no trademark similar to the above mentioned. Thus, it was simply impossible to find out and to say about any kinds of infringement and breaches of the law, simply because there was no grounds for that. Thank you.
Thank you.
Are there any more questions you would like to be answered?
No question.
So please parties proceed to the next stage.
I have only one question, just maybe it will be an advanced question for the final pleadings. Probably the defendants, I would encourage mainly the defendants to find out the possible solution to end up in a settlement. Probably you could have some idea starting from the crucial point which actually initiated this trial. Actually, that was the point at the customs clearance, at the customs authorities seized and temporarily stopped the customs clearance of the books. Probably if you have different markets and business models, you can end up in a settlement. And if you have any ideas what this settlement could be, you could suggest it to the plaintiffs, and that would be a win-win solution. This is a little bit out of the scope of the requirements of the moot court, but probably if you have imagination and would like to have like win-win solutions, we could be happy to hear that. Thank you.
Thank you
for your question, colleague. May I, if
Sure.
there are no objections, can we have with my colleague 30 seconds for discussion to answer that question? We have a, thank you. Thank you.
Well, we can present this, the answer to this question, and well, to present our idea of a settlement during our final pleadings, if it pleases the court.
Yes, that would be perfect. Thank
Okay.
you.
Thank you.
Thank you.
And I would encourage the plaintiffs to be ready to discuss, just actually, if you will be suggested some settlement agreement or some terms, to answer whether it will be a happy end for your client in this respect, please.
Sorry, we have bad internet connection. Can you repeat? It is also concern question our team or only respondent?
Yes, that was just a remark that me as the judge suggested that not every trial could end with like classic traditional dispute resolutions court decision, but probably the parties would be ready to end up with a settlement, like peaceful agreement, which could benefit both of the parties. So if you have any suggestions that will make your client happy in terms of what is the best solution for you, and probably you could hear some suggestions from the defendant side, that could be a very good ending of this trial. Thank you.
Okay, thank you. Okay.
Yes, thank you, the Honourable Court. Yeah, we have a idea for the peaceful settlement, and it would be following. We understand the hardships which occurred, and definitely it was they are because of the coincidence. And as the to say people of the world, we are not commercially bound by our ideas, and we actually can approve as the owners of the lawful owners of their trademarks and rights. We can approve and give the right for the plaintiff to use the above mentioned trademarks, but with an extension to the territories of Ukraine and India in order to compensate in these ways the lost profits. And now I will give the word to my colleague for the second part.
Yes, thank you. We understand that the problem at question was the blockage of, well, the literary work at the customs post. And so we are ready to offer use of our lawfully obtained and lawfully registered trademark for, well, full due payment, of course. And we would like to offer a deal on that would benefit us both, as we would like to perhaps order the batch of books in order for them to be distributed in Ukraine and in India. If such a solution would satisfy the plaintiffs.
Well, thank you. On our opinion, the peaceful settlement will be stop infringement, illegal use of the trademarks, and we can find an acceptable price for you to using in the future all those trademarks, and also. We believe that the peaceful settlement will be charging damages in amount of $100,000 because of the money that we haven't received because our law was validated.
So to rephrase, you do not accept our peaceful settlement offer?
No.
We offered ours.
Peaceful settlement, yes.
Well,
We offer you to use all those trademarks, and we can find an acceptable price for using it in the near future.
so do you mean royalty or something?
Yes, I mean royalty.
Well, judging by the fact that our trademarks have been lawfully registered and the plaintiff's side had not provided sufficient evidence for the Honorable Court to think otherwise, we simply don't understand why is the allegation of us using the trademarks unlawfully is still on the table, so to say. And regarding the damages of $100,000 of the United States of America, I believe we, as representatives of the defendant, Mr. Kyle, here, we can say that that the batch of books being stopped is not our fault. If you have objections to them being stopped, you should probably refer these objections to the to the customs.
We have presented our way of seeing our settlement of dispute.
Dear defendants, I must interrupt you because we have very little time, and since we have heard your positions about the peaceful offer, please proceed to the final stage of the proceedings so the applicants can represent their final claims and representation. You have 2 minutes, and after that, the defendants will have 2 minutes as well.
Okay, we ask the court to stop infringement, illegal use of trademark, and prohibit to continue use of such trademark. The first, trademark Martin State variable mark. The second, international trademark application number 0001111. The third, trademark Martin variable mark. 4, international trademark. The 5, the trademark device mark. The 6, international registration with extension to Ukraine and Poland, and stop infringement, illegal to use of industrial design, and prohibit the continued use of such industrial design.
design of exterior of the robot that is such the character of computer game margin and state and international registration of the hack system with extension to Ukraine and Poland, and also charge damages in the amount of 2,700,000 of hryvnias and others the respondent to pay the cost and expansions. Thank you.
If it pleases the court,
Thank
we'll
you.
proceed with our...
Yes, defendants can proceed. Please.
Right. So on behalf of Mr. Kyle, we reject the claims to stop trademark infringement, as we believe that no trademark infringement, no copyright infringement while using the trademarks, occurred prior to this court's session, nor is occurring right now, because as we already mentioned in our speeches, there is simply no connection between the game Martin's Estate and the short story Majetok Martina. And as we now know that the title of the game, Martin's Estate, was then used by Mr. Kyle because he purchased the rights to this trademark as well as the trademark of Martin. We believe that no violation of the law took place, and because of that, we reject the claim. Now, regarding the patent, as I believe it was mentioned by the plaintiffs, we reject the claim to recognize the patent as one lacking novelty because, as we have already mentioned, the short stories do not have the appropriate size nor the reason to involve all of the design specifications and to immerse the reader in all of the intricacies of the functioning of the mechanism. The same goes for the industrial design, as the appearance of the industrial design is submitted with the intention of focusing on the essential characteristics which constitute the unique nature of such a design, and and the claimant's short story merely has vague representations of an appearance of a robot protagonist in the plot, which are general by nature and therefore do not have the same essential characteristics that our industrial design has. And so with all the claims rejected, we see no reason for reimbursement of the alleged damages of, I believe, $2,100,000, as we do not have understanding on why such a large sum of money must be reimbursed in the first place, and secondly, because no infringement took place in the first place. And now a word to my colleague Dmytro Kirichenko.
I see the time
I'm
is
sorry.
up. Yeah, so
yes,
I will.
Dmytro, I must interrupt you because you have very, very short time. If you have just few words, okay? Please proceed.
Few words. The offer is still accessible, and it will be open for the signing for the period of 1 month from this day. Thank you.
Okay, thank you both parties. You were magnificent. Your work was very good, and your presentations was very well done. I have a question to the judges. Does any of the judges have a question or comment? If no comments,
just one clarification. Because it's all about the money. And just to clearly understand the settlement counteroffer by the plaintiffs, it's a question to the plaintiffs. What kind of royalties and for what you want to be paid? As I understand, you want some royalties to be paid to your client. I am not talking about the damages indemnification. It's just a separate question, but you have said that you would like to have some money's payment, and you never answered about interest of your client. The second question is about the customs clearance, the permit to allow your books be exported abroad. So what about the money, and what about the export of books which are seized at the customs border? Please comment.
No.
About the first question about the royalty, yeah, we really wanted for our client to pay the royalty because his rights were violated and because of the illegal registration of trademarks for goods and services and industrial designs. And because of this, he had damages, losses, because he haven't an opportunity to trade his books to India, and he had lost profit. The point about royalty was not because of using it. No, about the peaceful settlement, we didn't want for our client to pay the royalty because of illegal using it in the past, but about the royalty for using it in the future.
So yes. Do you want the royalty for your book?
For using it as not as a book, as a trademark, trademarks name, verbal mark Martin Estate, verbal mark Martin, industrial design Martin's Estate.
Who owns the trademarks? Who owns the trademarks?
The owner of the trademarks is Kylie.
So it's not the owner of the trademark. Why are you claiming to pay the money for what you are not the owners?
Because there is, as we told several times, there is a Berne Convention which didn't allow to register any trademarks or industrial designs on any services and classes in any country of the country parties to the Berne Convention. And because of this, we argument that it was illegally registered.
Thank you. And what about the customs clearance? What about clearance about the export of the books? Is it interesting still for you? And can it the losses incurred?
It is. I don't think that it is still interesting because the terms of the contract are lost, and we will not receive any money because of this. Maybe in the future, by doing any discussions with the buyer of our books, we may find any solution. But now we haven't got any information about this.
Thank you.
Thank you.
So if no more questions and comments, I'd like to thank you all the participants, especially to the teams. I would like to repeat once again, you did a very good job. And regardless of who wins, please do not hesitate to contact organizers for any comments you would like to receive. And you have also invitation to visit offices of all the lawyers participating here. So don't worry and please contact us. Thank you again for your participation and for your job.
Thank you.